All right, are y'all ready on Decimito? And Ms. Ephraim, they're bringing your client up.
Don't move the number.
You're in a good spot. You're in a good spot.
Don't move up. Sit on the number. Do not move up, please.
All right, court is calling 2018 CR 12057, State of Texas versus Jessica Decimito. Could I have parties announced for the record for the state?
Garahan, Your Honor.
Defense,
Roger Pettis from Ms. Decimito, Your Honor.
are you Ms. Decimito? I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Jessica Decimito who was placed on community supervision for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on May 23rd, 2019 for a term of 5 years? Is that you? All right, state.
Yes, Your Honor. Violated condition number 2 on or about the 11th day of October 2023 in Bexar County, Texas. The defendant Jessica L. Decimito and did then and there admit to illegal use of controlled substance, namely methamphetamine, violation condition number 2.
How do you plead to that? True or not true?
We'll waive the remaining violated condition, Your Honor.
Any objections?
No objections.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, sentence you up to 5 years in prison and up to $1,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor. It is to revoke the individual off the probation, sentence her to 2 years in the Texas Department of Corrections.
All right, is that the agreement?
It is, Your Honor, if I may.
Yes.
Ms. Decimito, I have the honor to represent, is a U.S. Navy veteran. She has suffered from PTSD and some general anxiety, so she's had a struggle with drugs. As we sit here today, we have 844 days credit of Bexar County Jail credit. She's set to expire on her 5-year term here in just 2 months. In May, she's completed her community service hours. She did the parenting class that you requested, Your Honor. We believe, I don't want to talk out of turn, that we are either paid all of our money or there's a $70 balance. She's completed with the court's assistance and direction of the DDR program. She's done SAFE-P and she successfully completed that. She's currently a caregiver for her mother. The person that was in her life that helped continue to lead her down a path of challenging ways was her ex-boyfriend that we are glad to report as of July. He is a persona non grata. 7/31/2023, she turned him in and they have no further relations. Earlier or late last year, she presented ourselves, and I attended this to herself individually to a 30-day program at Laurel Ridge. She extended it on her own to 45 days.
All right.
She's a 100% disabled veteran. She works part-time with the gentleman who's here supporting her, Adam Gullen. She does some of the computer work for him. It's been a daily struggle, a challenging, but she's working through this. I think see on the Laurel Ridge program, we're ready to move forward. If you could give her the credit for the time served under this proposal, and we would be honored, Your Honor.
All right. Here's the thing. If I give her credit for time served, with the time she served, which I will, they're going to still take her into custody and she'll still have to be processed at the prison.
Okay.
All right. If you're drug tested today, what are the results going to be? I'm going to raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, can you lower your hand? State your name for the record. All right, what are you going to be positive for?
I might be positive for the
All right, so you're still using.
They have actually been abstaining. I honestly was pleading in counsel and I. I'm not gonna lie, it's good and
You used it.
Yes, I did.
All right, so. Well, no, I appreciate your apology, but you really should be apologizing to yourself and your body because drugs do bad things to the body. All right, so this is what the court is going to do. 1, you were on probation for 5 years. I can extend you, but you're going to go into custody today and you'll be referred to felony drug court. Yes. All right. Felony drug court is not going to accept you back. So it appears that everything has been tried. I can't think of anything else.
Touches that we also were treatment court. However, back when the referral was made, there were several attempts to get in contact with her and she did not respond.
All right. And so has she been to Safety?
On the veterans program, we do have a response on that.
Your Honor, during that time frame, I was incarcerated and the Veterans Treatment Program did not accept me. I don't know why, but they did not, and I was incarcerated. They did not respond to me and
All right. So here's the thing. I see that she's a veteran. I take that in consideration. I see that she has done some things. I know she hasn't lived up to the court's requests. I know that she's continuing to use. I can revoke her. She's going to come out with the same problems. Or I can send her back to Safety, extend her, and counsel if you want to see if Veterans Treatment Court will interview her at the jail, but I won't be releasing her from the jail.
In under the revocation program, would it be a 2-year sanction?
I will follow your agreement for revocation if that's what you all prefer.
I think
But
based-
either way, she's going into custody.
I think based on the situation with the number of days that she has, that she understands she is still struggling with this on a day-to-day basis. And I think we're appropriate with the 2-year sanction for jail with the credit for time served, if your honor could grant that.
All right. Are you waiving your right to appeal? Are you asking the court to follow this? All right. And I believe she may have used something today or sometime.
Not today. She is very nervous and anxious in the relationship that I've had with her. There's a very very nervous, anxious and nervousness to her personality.
All right. So this is what the court is going to do. I'm going to follow your agreement, grant the motion, sentence you to 2 years in the prison, give you credit for any time served, credit for any inpatient treatment. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? I'm sorry? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Which branch were you in? All right, so here's the thing, what I know about people who've been in the military. If you're able to go through boot camp and if you're able to serve, you can beat this, but you just got to be extra vigilant with it. You understand? And if there's anybody out there who's trying to get you off track of being clean and sober, they shouldn't be in your life. And when you're released from the prison, there are plenty of services available for veterans. If something happens and you can't find something when you get out, you can always come back here. If I'm here, you can always come back here to me and we will find something for you. Okay. All right. Thank you so much. Thank you for your service. Ruiz. All right, we're going back on the record in 2022 CR 4248A, State of Texas versus Jose Ruiz. Could I have parties announced for the record for the state?
Marissa Giannico and Allie Jackson and Brittany Mitchell and Spirit for the state.
Defense?
Lorraine Efren here, Mr. Ruiz.
And are you Mr. Ruiz? All right, over the break, the court reviewed all of the exhibits that were submitted. The court took into consideration and of course internalized all the arguments. The motion to suppress will be denied. All right, is there anything else from either side?
Not from the state judge.
Not from the defense this time.
All right. All right, if there are any other motions, make sure that you all have them heard before jury trial.
And Judge, I can, for housekeeping, the plan is to pick the jury Friday morning at 9:30.
Yes, 9:30, and it will be in the basement.
Yes, ma'am. And then, evidence starting Monday afternoon, is that what it is?
No,
Okay.
Monday at 9:30.
Okay, that's what I was
And
asking.
there's not going to be any of the cases, so it's going to be all day, each day. So everyone needs to make sure all their witnesses are here. And defense, if you have witnesses, what I usually do is I'll ask the state when do they anticipate on resting, so you can not be rushed up, have your witnesses here.
In your honor, I would, with regards to the motion to eliminate, I'll urge that Friday morning, but I guess I want to be clear that with regard to your ruling today, I, urge a motion to eliminate with regard to the contents of the cell phone, to be, they should be ordered to close before we.
All right, so what you all can do is when we actually start trial, whatever motions in limiting, or if there's something you don't want mentioned to the panel before jury selection, just let the court know.
Okay, and also during my argument, Judge, I said at one point to, you're setting aside 18.0215, and I just want to make clear that I wasn't suggesting that they set aside completely just for that moment of argument. So I'm assuming the court had a chance to look at that statute as well, or will look at it.
Yes, I did. Thank you. And just so everyone knows, I was aware of the case law that was presented, but even though I was aware of it, I still went back over my lunch break and reread the cases that you all were citing, as well as the cases that I cited. I reviewed all of the exhibits that you all submitted, internalized your arguments, and even reviewed the case law that I presented to you both as well. All right,
And I'm sorry, Judge, I've been told by two people that already knew. I just wanted to remind you, Brittany told you that when the trial got moved up, we do have some witness that the unavailability issues next week. They will be available on the 18th. We believe we're gonna go that long, but it could be an issue with timing if we're going all day.
Oh, we're going all day.
Okay.
And witnesses need to be here. Sure. Could you give those to Diana, please? All right. So Abby Marino.
We're ready, Your Honor.
Court is calling 2022 CR 6317B, State of Texas versus Abby Marino. Could I have parties announced for the record for the state?
Jason Gilligan, Your Honor.
Defense?
Andrew K. Hicks.
And are you Miss Marino?
Yes.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Abby Marino who's placed on deferred adjudication in 2022 CR 6317B for the offense of possession of a controlled substance, penalty group 1 less than 1 gram, on September 15th, 2022 for a term of 3 years? Is that you? All right, state.
Yes, Your Honor. Violated condition number 5 in Bear County, Texas. The defendant, Abby Moreno, then and there failed to report to the supervision officer as directed for the months of July 2023 and August 2023 in violation of condition number 5.
How do you plead to that? True or not true?
We'll waive the remaining violated conditions, Your Honor.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? All right, then the court will find violation of condition number 5 true. Is there a proposed agreement?
There is, Your Honor, and that is to revoke the individual offer of probation and sentence her to 180 days in in the state jail facility.
All right, so you're asking that she be revoked and sentenced?
Yes, Your Honor.
All right. Is that the proposed agreement?
That is the proposed agreement, Your Honor.
Are you asking the court to follow this agreement, Ms. Marino? Are you waiving your right to appeal?
Yes.
Are you waiving your right to appeal?
Yes.
All right, so you keep looking at your attorney. So do you understand what's going on here today? All right. Are you waiving your right to appeal? Are you asking the court to follow the agreement that you've reached with the state? All right, the court will follow your agreement. Court will grant the motion, revoke you, find you guilty. Court will sentence you to 180 days in the state jail facility. Give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. Good luck to you.
Thank you, Your Honor. May we be excused?
Yes, you may. All right. On Guion Hernandez. All right, who is his client?
I think it's Stilton Bailey.
All right, I think,
Yes.
yes, I gave it back.
Just showed up, they just got to say 4 minutes.
All right. Who's here on Albert Bishop? Why do I have this file? All right, I'm just going to go through the docket. All right, Jose Lozana is up for trial. So that's number one. Alexander Castro. All right, if you'll come forward. Norma, on this case, we're going to bring them back on 18th isn't spring break, is it? No, it's the 18th spring break?
It would be, well, no, I'm sorry. That might be spring breaks for some school, but not in the ISD, I know that.
All right, so it's not spring break for you?
No.
All right, so we're going to bring this on the 18th, and on the 18th, you are going to get a jury trial date.
It is.
Oh, okay. All right, Norma, we're going to bring this back on the 25th, and on the 25th, you all are going to get a jury trial date. So on Castro,
That is gotcha.
set it for the 25th.
25th.
All right. Does anybody have any objections to that?
Not from the state. Judge, that's just to pick a date for the future.
Yes, to pick a date for a jury trial.
Is everybody else going back to the job?
Yes. Guion Hernandez. On Guion Hernandez, let me see. He's in custody. There's an immigration issue. So Norma, on this, let's recall this back on April 8th. Sarah Wilson. Yes, where are we on this case?
Received an offer today. I've met with Ms. Wilson frequently. I know you're about to start a trial. I
Yes.
could take the offer to her again in the jail and then
All right.
if that line come back.
All right, we'll bring this back on March 25th.
Actually, starting in Capital that week in Cornell, that's for sure.
I want to bring it back on the week of the 11th or the 18th.
Week 11.
Yes, no, March.
Next week,
Mhm.
week of the 8th.
All right, Norma. What date can we put this on the week of the 18th? All right, we'll come back on March 21st.
Thank you.
You're welcome. All right, State, Sarah Keys is coming back on March 21st. And that's to see if she's going to accept the plea.
Thank you.
Santabanez.
Good afternoon, Your Honor. I'll confirm the state. I'm just waiting on off on that.
Okay. All right, thank you. Where's Mr. Santabanez?
Set up, please. Want him up here, Judge?
Yes, please.
No, it was not.
All right. So y'all gonna have to confer off docket to tender an offer. Ms. Ferguson, if you'll give me a date for this. Towards the end of April, maybe the week of April 29th, that's gonna be your plea deadline date. All right. Your plea deadline date is gonna be April 29th. All right. Do you have any questions?
Just regarding on maybe some type of deal so I can get back to work somehow or.
Oh, your attorney will talk to you about that. That's okay. All right, once he signs the reset form, he's excused. All right, John Lyles.
I'll put it on that.
All right. I don't have the file on John Lyles. Thank you. All right, John Lyles, he's being recalled for tomorrow. All right. All right, Norma, if you can put Lyles down for a recall tomorrow.
Thank you.
All right, thank you. Yes. Rosales. Oh, we completed that, did we not? Roberto Rosales, yeah. Okay. Gus Gallegos. On Gus Gallegos, Norma. They're supposed to have an agreed incompetency done today. So if you can schedule this sometime in May. Let's do May 2nd. We'll see where they are. All right, State, Gus Gallegos is coming back May 2nd. There was an agreed incompetency on him.
Oh, okay, yeah.
All right, Jose Gonzalez. All right, y'all need to confer off docket as far as discovery is concerned. Oh, he's not in custody. Have you received all the discovery?
Judge, there's CPS records up there I need to review. so
Okay.
that's for some time to consider it for-
All right, Ms. Ferguson, I need a 30-day reset for Gonzalez for discovery. And it's Jose.
He's like that.
All right, we'll come back on April 9th. All right, once you sign the reset form, you're excused. Thanks for dressing appropriately for court. All right, next person, Renee Cantu. Norma, on this case, this can be recalled for Thursday. It's Renee Cantu. All right, once you sign the reset form, you're excused. And that he'll be coming back on March 7th. There you go. Victor Garcia. All right, Norma, recall this for next week, and we'll see if his attorney, not next week, I'm sorry, recall this for the week of the 18th. All right.
Oh, thank you very-
Yes.
Okay.
Okay, thank you.
All right. Then I have Darianne De La Rosa.
That was NTR, Carlos Gold. I don't know.
Okay. All right, Norma, on this case, what day can you recall this for the MTR? All right, we're gonna bring it back on March 21st. Jose Lozano.
Garcia.
They are here for trial.
Oh, that's the trial case. Just give me a moment. I'm sorry. I didn't realize that was the trial case. Christopher Gonzalez. Christopher Gonzalez. All right, we're gonna bring you all back on March 25th. That will be for you. That will be for you to get a jury trial setting. We have another case that's going before yours.
Have to come back to get another setting?
To get an actual jury trial date.
All right.
Unless you all want to confer off docket with Ms. Ferguson in the back for an actual jury trial date.
Judge, what we prefer is a jury today, but.
Yeah, you're not number one. Ray, go talk to Ray.
I'll have a discussion on it.
Yes. So do y'all want to confer with Norma off docket for an actual date?
March 25th at work.
All right, so we're gonna come back for March 25th, Norma, on Gonzalez. And that's for them to decide a jury trial date. And I know that they have murder cases that are ahead of this, so that's why. But we're trying to get you through as quickly as possible. I'm only one person.
We appreciate it, Your Honor.
All right, thank you. Once you sign the reset form, you're excused.
Thank you.
You're welcome.
He's here on time.
And he always dresses appropriately for court.
Absolutely, Judge. Always.
All right, Marcelino Padilla.
Judge, we're present.
Yes, and you all want a jury trial, correct?
Yes, Your Honor.
All right, so on this one, if you want to confer off docket with Ms. Ferguson, you can. Otherwise, I can bring you back on the 25th for you all to get an actual jury trial date. And not have it set if there's a murder pending on that same day.
Okay, I'll confirm this, Ms. Ferguson.
All right, so Norma, on Marcelina Padilla, the state is and the defense are going to confer on a jury trial date for that. And if you'll place that date in the file, please. Brandon Sierra.
Present, Your Honor.
All right, we have this trial that's going, first you have a choice. One, I can recall you for March 25th, in which case everybody can review their calendars and we'll pick a date where there's not a murder case or some other setting that's higher than yours. Or you can confer off docket now with Ms. Ferguson on a jury trial date.
Okay, I'll confer with Ms. Ferguson.
All right. So Norma, on that one, if you'll confer with them. All right, thank you.
Judge.
Joe Andrew Blakely. Why do I have this file? Blakely? I didn't see this on the docket today.
Oh, it's on page 17, Judge.
Okay.
I think they were doing.
All right. So on Blakely, Norma, recall this for Thursday. And if Mr. Kimbrough is not here, we'll handle that. Yes. Okay. And then we have yours. Hi,
Judge.
bye. Have a good one. All right, Ray, are you ready with your case? All right, so where's your client? All right, we'll have the state move things around, court reporter will move things around, and then we'll take you all up. Whenever you prefer to do it, we can do it after.
Straight there. Copy of that.
Whatever.
I mean, that's what I.
All right, and Deputy Mejia, we'll take up the plea for Marshall White's client, and then we'll do the jury thing. And we'll have a break between then. Okay. Oh, yeah, no, that's what I'm saying. We'll take a break. We're just gonna do this plea. Okay.
They can't. I don't. That's a possibility, right? Yes. I mean, let me know. I mean,
You're gonna have a trial?
Okay.
You're gonna have a trial?
I'll get with you.
You think soon again, it sounds like you have.
Yes.
Okay. I just wanted to make sure our copy didn't break or, you know, wasn't sufficient.
All right, Bailey. Good afternoon.
Yes.
Oh, you ready? Okay, oh no, I can't see, we're in the different courtroom. All right, court is calling 2023 CR 10893, State of Texas versus Delton Bailey. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Marshall White, Mr. Delton Bailey, the defendant, Your Honor.
All right, and are you Mr. Bailey?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Bailey, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes,
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count one and the repeater status and proceeding on count two alone.
Any objection?
No objection, Your Honor.
I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand in count two, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Bailey, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, there's a $500 fine. State recommends deferred adjudication. They're taking in consideration 2023 CR 10884. Did you understand that to be the plea?
Yes,
Defense? State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, they have not.
Next, I'm showing you outside the agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, 120 hours of community service restitution, and you are to forfeit any right to the firearm in this case. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No objections, Your Honor.
All right, Mr. Bailey, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And Adriana, could you let me know the court costs for a second-degree felony? It's a drug case. Thank you. All right, thank you. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge. Respectfully, Mr. Bay has some support. Jennifer Will, the court with him today. I think he can make it through this probation and respectfully, I support the grant of the application. And I'll place him on the deferred adjudication for the
Right.
3 to 5.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
7 and 9.
Do they live with you?
I have them on.
All right. And are you employed?
I'm a welder, but it's case.
All right. And who is Salvador Rodriguez to you? And who is Edwin Eugene McAllister? All right. And when you say a relative, what is his relation to you? All right. There's gonna be a $500 fine that will be probated. The court costs are gonna be $385. Will you be able to pay that in installments? All right. Taking in consideration 2023 CR 10884. When's the last time you used any type of drug? So you never used drugs? All right. 5 years deferred adjudication. I'm gonna want regular UAs. If he tests positive for anything, file a motion to revoke. 120 hours community service restitution. I'm gonna order parenting classes. Once you complete parenting classes, the community service hours will be deemed satisfied. You're to forfeit any claim to the weapon. There's to be no contact with Salvador Rodriguez. Or Edwin Eugene McAllister. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to want field visits 1 time per month for 5 months. And then at probation's discretion. Probation, is there anything else?
Regular reporting.
Thank you. Regular reporting by Zoom or in person. Is there anything else you need from the court to be successful? All right. What's titled trial court certification of defendant's rights to appeal? Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. So from here on out, everything that you do, every decision you make, you need to ask yourself, is this something that could potentially result in me going to prison for 20 years? If it is, don't do it. And the fact that you're telling me you've never used drugs, then we know what's going on here, and that's not something your children should be around. You understand? All right, good luck to you. Probation will go over conditions with you.
Thank you very much.
All right, thank you.
Excuse me.
Yes.
Y'all have a good day.
Oh, you too. Are you all going to be ready on Lozano? Oh, you have something for me?
Yes, Judge, Brian Maldonado. Also here for
All right, could I see the file on Maldonado? Maldonado. Yes. They're gonna grab the file, then we take it out. Which page is he on? Let me see where.
It's 17, Judge.
Thank you.
Top of page 2.
Yes, okay, so on this case, of course, we're in a jury trial. So I can bring you back on the 25th for you all to decide on a jury trial date. Or it's gonna be a little bit hard for you to confer off docket with them for a jury trial date because they're about to start a trial. So if you all are able to come back on the
25th, Judge, I'm actually in Kennedy County, which is Cerrito, Texas.
okay. All right, when would,
That's what I do. If I can do it via Zoom, that would be.
Sure. that's fine.
Okay.
Okay,
May my client be excused on that day?
he can appear by Zoom if,
Here by Zoom?
yes.
Yeah. That should be fine.
all right. If there's some problem with his Zoom capabilities, just let the court know.
Sure.
And of course, I'll make allowances.
Okay.
All right, Ms. Ferguson will give you a reset form.
I will be in another port, so just.
Oh, no.
Okay.
No
Yeah.
problem.
And that's to pick a new date, Judge?
Yes, to pick a jury trial date.
Okay.
All right. There you are. So everyone on Lozano. Are you all going to, and we're not on the record yet. Let me find, are you all proceeding on the indictment as presented?
Yes, ma'am.
And of course, I know nothing about this case. So is he eligible? What's going on?
Yes.
All right. And are you going to the court or to the jury if he were found guilty? Okay. All right. All right. So, okay.
Election.
Yeah.
application.
Yeah, the application's.
All right. So then do y'all really need 20 minutes for jury selection? Yeah.
I'm not even part of this, so.
Yeah.
Probably.
All right. All right. I'll give you all 20 minutes. I know other people will give you 10, but I'm being, or 15.
I'm sure you're gonna cover a lot of things. So I'm not use all my.
Mhm. Okay. And so then there's no punishment phase.
You go to the dealer's one. Went and ran outside. That's nice. It's very nice outside.
And so this is theft 300,000 or more?
Yes, ma'am.
Okay. But here we have 20 more inmates for you to bring out. I have two more files. It is Albert Bishop. And I don't see what page Mr. Bishop is on. Okay. Which ones? I'm sorry, I put the wrong docket. Just 1 second. All right, sure. Oh, here we go. You say page 17? Are you talking about Kevin?
Yeah.
That was dismissed. Okay, let me go there. Yes, Mendoza, April 22nd. April 22nd.
And then 30.
Mhm. Now, there are a couple that are going to end up being a motion to revoke because they didn't appear. Robert Solis, I believe, is one of those. No, I have not done Bishop. That's Charles Gold. So, yes. What date do you want to put that on? All right. Everyone, we're going to put Bishop on March 21st. It's a stalking case, so I think that's family violence.
Might be, I don't remember, but I can't. Some of those are ours and some of those are, I mean, family violence. I don't know why.
I guess it depends on who the complainant is alleged to be.
Stalking their ex-wife or I don't know if an ex-wife is family or not.
All right. And the only other file I have remaining, Norma, is Jose Amiscus, and we're trying to figure that out, what to do with that one, because it's limbo. And then Diana, I'm sorry, Diana. I'm looking this way and looking at you. Adriana, I will have this for you shortly. You're welcome. Yes. Yes. No, this is Estrada with Ted Wood. And then I have Kevin Young. Okay. No, I like your nail color. Mhm.
Excuse me, Diana.
The IT guy.
Okay. Okay. All right, I will look at it. And I'll keep these together. Thank you. Oh, yeah, thanks. Yes, thank you.
That's so fun. By the way, Avon texted me back saying that, yeah, you can send off, the video.
Oh, no,
I left.
it's not, because I see my job as really to be a referee. So really, it's the defense and the state. They present their case how they present it, and then I just make a decision. And then when you have, for example, on motion to revoke,
I don't know.
they each have their viewpoint of what they'll recommend, and I'll consider that and take in consideration. But really, motions to revoke, that's saying that somebody violated a contract they have with the court. So really, neither party has much say in it. They can make their proposed agreements, but I don't necessarily have to follow them at all. And then, because once the person is on probation, they're on probation.
That's them the day of.
There are a few exceptions, but they can't come back and say, oh, I'm revoked now. I want to go to trial instead of having been on probation. They're not allowed to do that. But no, it's not that difficult because, and I think it's partially because I've done both sides and partially because I know everybody wants fairness. So, yeah. Now, of course, if there was an offense and the complainant was alleged to be my mom, I couldn't be fair, you know, but otherwise, sure.
Even if the other guy just.
Sure.
It's still, you were willing.
Recused, yes, yes.
And I think the family probably would understand. Thank you.
Oh, sure, no problem.
Yeah, I mean, right now we don't have one.
Two birds with one stone.
So what's gonna happen is we're gonna do jury selection. And I'm going to give them an update, and then once I give them a little bit of information, then both the state and defense will have 20 minutes to give information that they want to give, and then we'll have a jury selected. No, you're not. The only time they'll learn facts of the case is if they're on the jury. The reason why they do that is because the jury is supposed to be impartial. So let's say you spin things and say, well, I think John Doe committed this robbery case. And let me tell you why. John Doe went to this location, this person is gonna say this, and this person is gonna say that. So how are you gonna vote on it? Then that's not really a fair jury, because they're supposed to be impartial the way I am. You're just supposed to sit and listen to a witness and make a decision. Is this witness telling the truth or not? Because otherwise you won't have any jury trials. You could just have the state and the defense, put 12 people in a box and just get their spin. And the person who will win will probably be the person who spins the best. Right, so.
Can you prove between 150 and 300? You don't know. You have to ask for two of them, right? You have to go all the way down to third degree as a, up to 150, right?
Yes, and basically you're really just looking for jurors who are going to listen to the evidence and base their decision upon, based upon the evidence they hear and nothing else.
30,000 for sure, right?
All right, as soon as Diana comes back, we will line them up. Hey.
Yeah.
Sure.
So.
Okay. Mhm. Let's do that. I know they're not gonna, but I know as long as there's a hold on him, they're not gonna take him. He's just gonna be in limbo. So what we'll do is I'll alter him in conditions. And I'll just put it at the bottom. So we'll alter him in. Okay, sure. And to include intensive outpatient treatment.
Oh, that's true.
Yes.
That's how you set it up already.
I'll just. Go any short. I'll see you tomorrow. Are you sure? Yeah, well, we're gonna be. We went to. Okay, just making sure. Yeah. I know you do. And it's here the night.
I'm the problem.
Rio in here. No, man, it's. My little toes are cold. Good. She's only visiting. She don't live here.
She doesn't live here. What, is she trying to make changes?
She allegedly is calling it's not. You don't live here.
Okay, so here we are. All right, is everybody ready? All right, court is calling 2021 CR 7016, State of Texas versus Jose Lozano. Can I have parties announced for the record for the state? Defense? All right, and so it's the court's understanding that both parties are ready for trial. Both parties are proceeding on the indictment as presented, is that correct? All right, so each side will have 20 minutes. Is there anything else?
We're gonna take that up in the motion, let me in terms of what permissible, what's not. I'm gonna
Yes.
open for arguments. I want to make sure on the record. Like I said.
All right. Is there anything else? All right, we'll bring the jurors in.
One.
Number one. Come on. First row at the end, first row on the bottom at the end, it has the numbers on the chairs.
You didn't see that.
Number eight, second row on top.
Okay.
Who's 15? 15? On the first bench, has the numbers.
Mm,
22,
yes.
next row, sir. 30.
One more time here.
All right, everyone, please be seated. All right, ladies and gentlemen, I want to thank you so much for your patience. I know we're starting later than anticipated with this jury selection, but believe it or not, we had a lot of cases on the docket this morning. And so those cases were unrelated to this. And so I had to take up those matters. So this case is the state of Texas versus Jose Lozano. I'm going to have the parties introduce themselves to you for the state.
Yeah, the US from the state.
Good afternoon. My name is Hank Wilkins.
Good afternoon, Raymond Martinez.
Victoria Cruz for the defense.
And Mr. Lozano, Jose Lozano.
All right. Is there anyone here who recognizes or knows any of those parties? If you do, please raise your card. All right, that's number 44. Thank you, Mr. Wheat. All right, you all are in the 187th District Court. You're on the 4th floor. I am Judge Boyd. So which floor are you on? All right, and which court? And who's the judge? All right, you're probably saying, why am I asking that? It is because whenever you all separate, when we take a break, sometimes people get lost. And if you remember the 187th, this is the only 187th District Court in all of Texas. Or if you forget that, if you remember Judge Boyd, I'm the only Boyd in the entire courthouse in San Antonio. So you'll be able to remember if for some reason you get lost, because sometimes the courthouse can get complicated if you're not here on a regular basis. In your possessions, you have cards. Could everyone please raise your card for me? And if you will keep those raised until I ask you to lower them. Whenever you have something you wish to say, or if somebody asks a question and it pertains to you, please make sure that you raise your card and the person will call out your number and then they'll ask you about that. So everyone in the box, if you could lower your card, please. The people on this first row, starting with juror number 15 all the way to 21, if you could lower your card. If you have your card still held high, what that means is in order for the court reporter to hear you, if at all possible, we'll need you to stand when you're responding. Otherwise, it's very difficult for her to hear. I think we've been in jury trial every week or every other week. And so far, no jury has been able to follow those instructions. But I'm going to tell you what I told the last jurors. I have faith that you all will follow those instructions. So you can lower your cards. All right. The charge in this case is theft, $300,000 or more. When the state and the defense talk to you during this jury selection, they are going to talk to you about hypotheticals. They are not allowed to tell you what they think the facts are in this case. So when they're asking you questions, do not start thinking in your mind, oh, they're talking about Mr. Lozano, because they are not. These are all hypotheticals that they're going to be telling you about. The only time you will get to know what people think the evidence is in this case is if you are selected for the jury. Does everyone understand? Now, how many people here have seen, I don't know, Paper Chase? That's my age. Mannix, Beretta. Thank you, juror number 16. Mannix, Beretta, I think they have The Practice, all these legal shows, right? So how a person gets to have a jury trial in felony court, there first has to be an indictment. An indictment is not evidence of guilt. It can not be taken by anyone as evidence of anything. It's just a means whereby a person is brought to court. For example, I'm going to practice with you all raising your cards. How many people here have had a traffic ticket? Don't be shy. All right, the trend continues. We have a lot of bad drivers. So you can lower your card. I've had one traffic ticket in my entire life. So I'm only 21 now, so I'm doing good. Okay, there shouldn't be that much laughter. You should say, oh my gosh, she's so intelligent. So when I got my traffic ticket, that's when officers still had a paper book and you get a piece of paper and they carry around this thick binder. So now my understanding, they do it electronically. So let's say an officer pulls you over and they say that you ran a red light. They pull you over, they say, I'm pulling you over, you ran a red light. Here's your ticket. When you accept that ticket, you're not saying, oh yeah, I did run that red light. Basically, it is just telling you, this is what you're being charged with, and you need to come to municipal court on this date to answer for this. It is not evidence of guilt. By you accepting the ticket, you're not saying I did it. It's the same thing with an indictment. It's just a means to tell somebody, hey, this is what you're charged with, and this is the courtroom you need to be in. Does everyone understand? Is there anyone who's going to hold it against Mr. Lozano because he is here under indictment? The next thing I want to talk to you about is the right to remain silent. Everyone has the right to remain silent. What does that mean? That means that you don't have to testify if you don't want to testify. I've been a defense attorney. I've been a prosecutor. Sometimes I would have a client, they would be extremely nervous. And I would say, you know what? You're going to be extremely nervous. I'd work with you. You shouldn't testify. Or either sometimes the state would present their case and I would tell my client, you can testify if you want to testify. It's completely up to you. However, I don't think the state has proven your case, so there's no need for you to testify. This is not Bewitched with Mrs. Kravitz across the gate, where Mrs. Kravitz wants to know what the person who's accused did. What would they say? That's not allowed in this courtroom. Does everyone understand? So if someone chooses not to testify, you cannot hold it against them. And there are many reasons why people would choose not to testify. Like I said, sometimes maybe your attorney says it's not necessary. Sometimes you're extremely nervous. Sometimes you may stutter. There are a host of reasons. The key point is, if Mr. Lozano decides not to testify, You cannot hold it against him. You cannot take it as evidence whatsoever. Is there anyone here who will not be able to do that? If that is you, raise your card. All right. The next thing I want to talk to you is about the presumption of innocence. Everyone is presumed to be innocent when they are accused of a criminal offense. So what does that really mean? That means, as Mr. Lozano sits here now, he's presumed innocent. So if you had to vote right now on whether he's guilty or not guilty, your vote should be what? And the reason for that is you have not heard anything in this case. The state has the burden of proof. That never shifts to the defense. When I was in law school, the professors would tell us, as a defense attorney, you could sit there, you can play crossword puzzles, you can do video games, you can do all of that. And they were just telling us that to say, that is how strong the presumption of innocence is. Of course, when I was trying cases, I never did that, but you could. The state has the burden. They must prove each element of their case beyond a reasonable doubt. What is the definition of proof beyond a reasonable doubt? When I was in law school, we had a definition. You felt like such a failure if you could not memorize that definition and recite it back. I had my first jury trial. I recited that definition. I paused where we were taught to pause for dramatic effect. I added the explanation point where it needed to be. And then after my first jury trial, guess what? There's no longer a definition for proof beyond a reasonable doubt. So neither the defense nor the state can give you a definition for it because no definition for proof beyond a reasonable doubt exists. So when I was a defense attorney and when I was a prosecutor, how I would explain it to jurors was by telling them what it was not. Next door is the historic courthouse, the one with the green rooftop. They try civil cases. When you have cases involving money, usually the burden of proof is preponderance of the evidence. More likely something happened than not. So if you're ever on a criminal jury and you are deliberating and you find yourself saying, oh, I believe this happened more likely than not, you know you are not at the correct burden of proof. Does everyone understand? Oh, you all are whispering that. Does everyone understand?
Yes.
Okay. The other burden of proof, the highest burden on the civil side, is what's called clear and convincing evidence. That's the type of evidence that's used when they say you're a bad parent, we can't trust you to take care of your children, and we're going to terminate your parental rights to your child, which means legally you no longer are a parent to a specific child. Does everyone understand?
Yes.
That's a very high burden. Guess what? Proof beyond a reasonable doubt is a burden that's higher than that burden. Does everyone understand? All right, there are two phases to a criminal trial. First phase, people always call it guilt innocence phase, but it really is not that. What it really is, first phase, did the state prove its case or did they not prove their case? Is a person guilty or not guilty? That's phase one. If someone is determined to be not guilty by a jury, there is no phase two to the trial. Phase two is what's called a punishment phase, if someone were found guilty. In Texas, the law is that a person must elect or make a selection that if they were found guilty, either they would have the jury decide punishment or either they would have the court or the judge decide punishment. Now, the law says that person must make that election or that selection before trial begins. In this case, Mr. Lozano has decided that if he were to be found guilty, he would come to the court for punishment. Is there anyone here who has an issue with that or a problem with that? If you do, raise your card. All right. Next question. This trial is going to start tomorrow at 1:30. And I'm anticipating, I think the trial will be done before Friday, or at least by Friday. Is there anyone here who has some type of time constraints as it relates to those days, or at the latest on Monday? If you do, please raise your card. Once I call out your number, you can lower your card. Number 1, 4, 18, 19, 25, 27, 30, 34, 35, 41, 42, 43, 45, 61, 65, 66, and 72. All right, number 1, what's your time constraint? I'm sorry, what? Work, what do you do? All right, oh, serverware. Okay, all right, thank you. Tell them sometimes their steak is not to order, but okay.
Just for the record, 17 also raised their card.
All right, thank you. Number 4? Yes.
I'm going out of town Thursday,
Oh, where are you going?
Kansas City.
Why are you going to Kansas?
My aunt's getting married.
Oh, people say, oh, but here's the thing, does she want you there?
Sorry.
Does she want you there? What is your role in the wedding?
I'm just there to go.
All right. All right, thank you. Congratulations to her. Number 18.
Your Honor, I have appointments from Friday. I pushed out from today,
All right, what appointments?
homeowner appointments.
What does that mean?
I'm a construction superintendent. I have to turn over homes when they're ready. I had appointments for today, but I pushed them all out to Friday.
Okay. Number 17.
Hello. I'm scheduled to work the rest of the week. I don't know if that matters.
I'm sorry, what?
I'm scheduled to work the rest of the week. I don't know if it matters.
Oh, what do you do?
I work for HEB.
All right. You know, once when I was in HEB, someone took the bread and butter pickles off the shelf, opened them, reached in and put them back. But I did inform the manager, so keep an eye on that. All right. It wasn't a worker. All right, number 19.
Yes, I have a school,
Oh, where to?
SCBT, it's a trade school.
Is it in person?
Yes,
And what are your days?
Monday, Wednesday, and then the rest of the days are online.
All right, so Monday and Wednesdays.
Yes, ma'am.
All right. Number 25. Don't disappoint me.
I have work the rest of the week.
What do you do?
I'm training to be a fraud prevention agent.
All right, thank you. Number 27.
I organized a meeting for my HOA and I'm in charge of this meeting. Cancel it, but you know, the inconvenience, the whole.
All right, which HOA is this?
Elkhorn Bridge.
Okay. And when is your HOA meeting?
Day after tomorrow at 11 a.m.
All right, 11 a.m. You're not going to get many homeowners to show up?
Well, it's the ladies in the subdivision.
Okay, all right, thank you. Number 30.
Have to take care of my.
All right, what are their ages? 2.5 and 8 months. They're not driving yet? Okay. All right, thank you. Number 34. All right, thank you. Number 35.
My spouse needs picked up for a medical procedure on Friday.
All right, thank you. 41.
I'm a caretaker for my mother and she has a wound nurse that comes to the house 3 times a week. So I'll have to be there on Wednesday and Friday. She has an appointment with the wound doctor.
All right, thank you. 42.
I have a 10-year-old son that has to be picked up from school, and I also have a son that's 38, that's autistic, and I'm his caregiver.
Okay. You can't have the 10-year-old take care of the 2.5 and 8-month-old?
The 10-year-old's in school.
All right, thank you so much. I appreciate that. Number 43.
Yes, I also have to take my son to school and pick him up. And I have a scheduled work.
All right, what's your son's school hours?
He goes in at 9 in the morning. And I have to pick him up at 4.
What time?
4.
All right, thank you. Number 45. I'm sorry, could you speak up a little bit? I'm sorry to hear that. Thank you. 61.
I teach on Thursday. And also I'm scheduled to be out of town on Saturday.
All right, what do you teach?
I teach the marriage law,
All right, and what subject?
conflict laws, trademark.
All right, so I think everybody here is a St. Mary's Law graduate, so hope we're doing you proud. And Saturday, where are you headed?
Heading to California.
What are you doing in California?
I'm moving my son out of his door.
All right, thank you. 65?
My wife had a doctor's appointment. She has Graves' disease.
Okay,
I'm the only one there to take care.
all right, and when is the schedule?
The schedule for tomorrow, she have an appointment tomorrow. She have none.
All right, thank you. 66.
Because I have 2 doctor's appointments on the next 2 days and then I have work on Friday.
All right, thank you. 72?
I have an NGA national conference in Las Vegas, and I'm headed out on Sunday.
All right, is that really is what happening in Las Vegas? All right, and what time is that?
I leave at 6:30 in the morning on
6:30 a.m. when?
Sunday morning.
Sunday. All right, thank you.
Turn on.
All right, thank you. All right, is there anyone here? I think languages are so beautiful, but is there anyone here, English is not your first language? All right, if you'll turn your card around, this person over here. What's her number? Okay, 37, 61, and 75. All right, number 37. What is your language? All right, have you been able to understand everything? All right, how do you say hurry up in your language? All right, see, I'm learning. Thank you. 61.
My native language is Chinese.
Oh, okay. How do you say hurry up? Oh, thank you. I'm gonna remember that. 75. All right. And I know there are several ways to say hurry up in Spanish. Give me your best one for me. All right. And have you been able to understand everything?
Mostly,
All right. What does that mean mostly?
I understand most of what you're saying.
All right. If you can stand up, please.
I understand most of what you're saying.
All right. So did you go to school here or no? And how long were you in school here? All right. Thank you. All right. Before I turn it over to the state and the defense, I'm going to tell you all 2 stories. Both of them are true. I understand that jury duty is an inconvenience. And I'm calling it an inconvenience because that's what it is. Because when you think about it, your country only asks 2 things of you: pay taxes and jury duty. And when they ask for jury duty, they're not even asking you to do it every month. I know there's probably some people here, this is your first time ever being called up, maybe somebody 2 times. But I have yet to have somebody on a panel who's been called up at least 3 times. So that is all your country is asking for you. I know it's an inconvenience because guess what? You got here at 8 a.m. maybe, and you thought you were going to be late, so you were rushing. And then you realized when you made it where you needed to be, it was hurry up and wait. And then you were called up for the 187th. You were out in the hallway waiting. It's probably hot out there. There are not adequate seating out there, even though I've tried to change that. Then, if you don't know your way downtown, the building is right there. If you could just turn left, you would be right there. Instead, you have to make that entire circle. Then you have to find parking and you have to pay for parking, and it's expensive. I understand that. So it's an inconvenience. This is why I say it's an inconvenience. My uncle grew up in a small town called Grand Cane, Louisiana. I'm originally from Louisiana. People always hear my accent when I have to say soil and oil. So anyway, he was my grandmother's firstborn. Super intelligent. They would pass him from grade to grade in school because they say, we've taught you all we can teach you. And they would pass him up and up. So his siblings came behind him. My grandmother only had 2 boys in the family. The rest were girls. And so when they came up behind them, the teachers would say, we're expecting a lot out of you because your brother has set the bar, so you better bring it. So my uncle graduates from school, but he graduates early because he's been passed and passed. And the Vietnam War breaks out. And he goes to my grandmother and he says, they're already drafting people. I know that if I want to better my lot in life, the best way for me to do that is to join the military. So when you think about it, my grandmother had to sign for her son, her firstborn, to go off into the military. It's not, young people, it's not like today where you can just have a computer or even have TV 24 hours a day. That was in the time period where you had 3 stations, ABC, CBS, and NBC. And NBC technically didn't count because the weather had to be perfect. Even if it was sunny, if there was a breeze, NBC, you're probably going to get some lines running through it. And then there was a certain time where the television just cut off because there's no 24-hour news cycle. There's none of that. And if you're lucky, I think ABC and maybe NBC started doing that thing where when the television is about to cut off with no more programming, they'll play the national anthem. That's how you know this is all we got for you people. And then maybe the flag would continue to blow, but on one of those stations, it would just be a white line and you're done for the day. My grandmother had a phone, and that phone wasn't where you just dial your number. That phone, you pick up, the operator answer, and they say, may we connect you? And that song, Beechwood 74569, that's how people would call on the phone. I'll slow down. You know, you pick up the phone and you say, this is the exchange I want. So when you think about it, my grandmother did sign for him to go to Vietnam. The only way she had of contacting him was the military just tells you. This is what you put on the letter. Nobody knew where Vietnam was. And so she sent him off and she had to write a letter, hoping that he made it where he was supposed to make it to. And then once he made it to Vietnam, she sent a letter there and it wouldn't come back for months and months later. So she didn't know if her son was dead, if he made it okay. And you know, it's one of those things, they still do that to this day in the military. When people get in the military, they tell everybody, sit down, write your mom and dad a letter. So he did make it back. He has since passed. My grandmother has since passed. But I tell that story because I want you all to know your government really isn't asking that much of you. There's no longer a draft unless something changes. The other story I want to tell you is about my friend from law school. She decided to practice civil. I always loved criminal law. It was my passion. We hadn't seen each other much because on the civil side, usually you're in your office doing a lot of paperwork. So she gets called up for jury duty. And she says, Stephanie, I'm called up for jury duty. Let's have lunch. I'm like, great. So we have lunch. I say, how is jury selection going? She's like, fabulous. Now that I'm a judge, I'm wondering, how could it be fabulous? Because you're not in judge with Stephanie Boyd. But she tells me, oh, I'm not going to get selected. I'm like, what do you mean you're not going to get selected? She's like, it's just like law school. I'm at the back. I'm avoiding questions. I start laughing. She says, what's so funny? I said, we're going to have lunch all week. So other than being silent, the perfect way to be on this jury is to raise a card and say, please pick me. All right, with that, I'm going to turn it over to the state. Does anyone need a break before I turn it over to them for questioning? All right, so I'm going to turn it over to state. State, you have 20 minutes.
Before I get started here, number 73, am I projecting enough? Can you hear me if I'm standing back here? Yeah. Okay, what about y'all in the back? Can you hear me okay?
Yes.
Okay, so before we get started here, I just want to ask y'all as a group, does anyone know when they poll large groups of people what the #1 greatest fear is? I can tell you it's not driving on 281, although that is my greatest fear. Can anybody tell me what the #1 greatest fear is? Somebody said it over here. Sorry, what number are you? Public speaking. Okay, can you tell me why? Number, and that's number, are you number 3? Sorry, 10. I have it back. Can you tell me why public speaking is everybody's greatest fear? Yeah, absolutely. And fear of judgment is the way I would say that. So I wanna let y'all know that we are not here to judge y'all, okay? Y'all are here to judge us. And the evidence that we bring, because we're the state and we carry the burden in this case. In this case is the state of Texas versus Jose Lozano. And so what we're doing, the reason we're doing this jury selection is we're trying to find fair and impartial jurors. Okay, so like the judge says, we're not going to discuss the specific facts of this defendant's case. So these are going to be a lot of hypothetical questions. We're trying to find, well, fair and unbiased people to sit on this jury. So when we talk to people, a lot of people don't like that term bias, right? But my example for bias, can anybody tell me who this is? Can you tell me who that is? No? Number 3. Do what? I'm sorry. Willie Nelson, yes. Why is, how do you know this person?
He likes to smoke marijuana.
Yes, okay. Can you repeat it for the court?
For country music.
Okay, famous for country music, but also, yeah, that's where I was getting at. He's a marijuana enthusiast, okay? So, number 4, would Willie Nelson be a good juror on a possession of marijuana case? No, probably not. Okay, number 3, tell us why again? He enjoys marijuana, right? So that's what we're talking about with biases, right? Those are not necessarily bad things, right? This is just, you might not be right for this particular case. And that's what we're trying to find out. That's what me and Daniel are trying to figure out as well as the defense here. And we want to encourage you to use your common sense, right? So don't leave your common sense at the courthouse floor. So these are the elements that we have to prove to y'all in order to secure a guilty verdict in this case. So in Bexar County, on or about a certain date, the defendant with intent to deprive the owner of property unlawfully, without effective consent, appropriated property, and it lists out different kinds of property, valued at $300,000 or more, okay? And we're gonna break that down. You don't need to be taking notes. You'll get all this at the end if you do wind up on the jury. But the first 3 elements, all we need to prove are these elements, these 7 elements, and that's it. But the first 3, I'm not going to spend a ton of time on in Bexar County on or about a certain date from the defendant. But I want to talk to you a little bit about intent. Okay, intent, the legal definition is acted with a conscious objective or desire to cause the result. So if I've got my clipboard and I haul off and I say, I'm going to hit Daniel with this clipboard, I hope that hits him. That's intentional. Okay, I did that on purpose. So that's what's meant by intent in the charge there. You can look at the surrounding circumstances to prove intent. So we're not asking you to read anybody's mind, okay? You can infer intent from acts, words, and conduct of the accused. Deprive. Deprive is defined in the code, but that just, it's a pretty common definition. You guys know what that means, right? Does anybody have a problem with deprive?
No.
Okay. Unlawfully, without effective consent, appropriated property. Okay, so you took something that didn't belong to you. Does anybody have a problem with that element? Okay. Unlawfully. So this is defined in the code too. Unlawfully means without effective consent. So I know you're not supposed to use the definition of something, the word in its own definition, that the legislature did that in this case. So that's what that means. Does anybody have a problem with unlawfully? Took something that wasn't yours, basically. Okay, and then we list off the things that were taken, and then the valuation. Does anything jump out at y'all that we don't have to prove that might be surprising? Okay, that's pretty open-ended. Why? We don't have to prove why to you. Does anybody have a problem with that? Is anybody going to not be able to find the defendant guilty if we can't tell you why these items were taken? Anybody? Okay, and so that ties into the rights of the defendant, right? The defendant, like the judge says, he doesn't have to testify, right? And so we can't, that might be something we just can't bring to you. Can't tell you why something happened. But that's not a necessary element that we need to prove to you. Okay. Can anybody tell me when things are typically stolen? Number 5, when are things typically stolen?
At night,
At night. Okay, yeah. Why is that? Why do you think that is?
people are asleep or out.
They're asleep or they're out, right? So why might you steal something when people are asleep?
Because they're not aware of their surroundings.
Yeah, if you're okay, yeah. So I'm sorry, could you repeat that last part for Diana?
They're not aware of their surroundings.
Okay, yeah. So if somebody's asleep, they can't be a witness, right?
Mhm.
Okay. And are there always witnesses to thefts?
No.
And for some of the reasons you just said, right? Is there anybody that would require us to produce an eyewitness? Anybody that's gonna say, look, Hank, I get what you're saying. You might be able to prove this a different way. But I need somebody to have seen the theft occur. Does anybody feel that way? In order for me to find somebody guilty, I have to see them take the item. Does anybody feel that way? Right. Okay, so if you recover all this stolen property, was there still a theft? Sir, what do you think? What number are you? I'm sorry, number 6?
Number 6.
Number 6. So if somebody recovers all their property that was stolen, was there still a theft?
Yes.
There was, okay, but they got all their stuff back.
Right.
Still a theft?
Yes.
Yes, okay, and does everybody agree with number 6? Does anybody disagree? Does anybody say, you know what? Somebody stole my bike, but I got it back? No theft. Anybody feel that way? Oh, sorry, number 1, I missed you. Okay, but it's your bike, right? And so if if you got it back, did somebody take it? For a little bit. Okay, but to you, would that still be a theft? And look, I'm sorry, I should have said this at the top. There's not a right or wrong answer, okay? I just want to know your opinion at this point. So if that's the way you feel, that's okay. I'm not trying to change your mind. We just gotta know, we gotta ask, right? Because later on, it's gonna be like, well, you know, like this is a theft. And if that's not a theft to you, I just need to know. Okay, does anybody agree with number 1? Anybody else feel that way? What if you only recover some of your property? So number 7. So let's say you got a couple of bikes. They're taken, you get one of them back. Is there a theft?
Yes.
Yes, and why?
I don't have all my stuff.
You don't have your stuff.
I took it without my consent.
Okay, does anybody feel differently to number 7? Okay, so would anybody be unable to find someone guilty of a theft if the stolen items were recovered? Anybody, number 1, what do you think? Okay, so if somebody stole your bike and you got it back later, we proved that to you. Would that still be a guilty for you of theft? It would? Okay. Does everybody feel that way? Does anybody feel like, you know, listen, Hank, I get what you're saying. It's a theft by the legal definition, but if somebody gets their stuff back, that's no longer a theft. Anybody feel that way? No? Okay. All right, so these are scaled questions. Diana hates these, so I'm sorry about that in advance. Depending on the circumstances, it's okay for some people to steal. Does anybody, let's do this section right here. Does anybody strongly agree with that? Does anybody at number 1 from this area? No? Does anybody at 2? Does anybody agree with that statement? Number 3? Okay. So we got number 1 and number 3. Anybody else from right here? Okay. Does anybody number 3 disagree with that statement? So is everybody else at number 4? Is everybody else strongly disagree? Can you hold up your numbers for a moment? Okay, so for that one, that's 2, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 14. Okay, thank you all. All right, so same question for this part of the room. Depending on the circumstances, it's okay for some people to steal. Is anybody a 1? No 1s? Do we have any 2s? Okay, number 2s, we have 29 and 43. Okay, do we have any 3s? Or 3s over here? Okay, we got 15, 20, 21, and after I say your number, you can put it back down. Thank you all. 22, 24, 25, 26, 31, 34, 35, 37, 39, 42, 45, 46, 47, 48, 49, 52, 54, and 56. Okay, is everybody else a 4? All right, can you hold up your numbers if you're a 4? Okay. 16, 17, 18, 19, 27, 28, 30, 32, 36, 38, 40, 41, 50, and 55. Number 44, did we get you? Number two, okay. You get that one, 44. Okay. And then start rounding out third base here. Can I get the ones from this area? Anybody a one? No. Okay. Anybody a two? Okay. Number 75 is a two. Anybody else for two? Okay. Number threes. Okay. 59, 58, 57, 61, 62, 63, 65. And can I get the number fours? Okay, number four is 60, 64, 66, 67, 68, 69, 70, 71, 72, 73, and 74, and 67, sorry, I missed you. Okay, thank you all. Okay, has anybody here been the victim of a theft? Has anybody actually had their bike stolen? No? Okay. All right, we got a lot of numbers here. Danny, are you ready on this one? Might be easier to go the other way. Okay, I'm sorry. Who has not been the victim of a theft? Okay. All right, so we're going 1, 4, 6, 7, 9, 11, 16, 23, 24, 27, 31, 32, 35, 40, 56, 57, 58, 60, 63, and 69. Okay, and of the folks who have been the victim of a theft, who didn't get their stuff back? Most people. Okay. Has anybody been the victim of a theft over $300,000? I'm sorry, man. What number are you?
29.
29. Okay, what got taken?
A bunch of my jewelry.
A bunch of
All
stuff.
gold, yeah.
Okay.
Family member.
That was a family member? And did you recovered any of that or? No. Sorry about that. Anybody else have a similar experience? Okay, has anybody been the victim of a theft that was maybe less than $300,000 but more than $150,000? Number 33, okay. What was taken from you? Clothing, okay. All right, so I want to talk about our burden in this case. We have to carry the burden in this case. We have to prove this case to you beyond a reasonable doubt. Like the judge said, there's no legal definition. I can tell you that it's not beyond all doubt. I can tell you that possible does not always mean reasonable. Okay, so you all see this picture up here? Okay, I'm sorry, sir, what number are you? 8, number 8. Can you tell me what's going on in the picture here?
Dog in the middle of the kitchen with a mess.
A mess, yeah. There's a trash all over the place. So what do you think, what happened to this picture here?
I don't know what happened.
Okay, sure. And so it looks like me, can anybody tell me what it, number, do what? Okay, yeah, number 1. So why do you think that? Uh-huh. It looks like we might have just eaten some delicious trash, right?
All right, 5 minutes.
Sure. Now is it possible that a raccoon busted in there, knocked over the trash can, made a mess in the kitchen, escaped and framed the dog? Did the raccoon have framed the dog? Sure. Sure, yeah. So that's possible, right? But I would submit to y'all that that's not reason. There's a difference between possibilities and reasonable doubt. And so that's my example for reasonable doubt. Okay, you can't let bias, prejudice, or sympathy influence your verdict. You can't say, oh, I feel bad for the guy, I'm not gonna find him guilty. The defendant has certain rights, right to remain silent, right to a trial, right of subpoena power. His defense attorneys can subpoena folks, so they can come in here and testify. He has the right to testify. That's not an obligation, though. He doesn't have to testify if he doesn't want to. The law says you treat defendant testimony like any other witness. So whoever's on the jury, y'all can decide to believe all, part, or none of the defendant's testimony. The defendant is presumed innocent, not honest, okay? Does anyone have a moral or religious problem sitting in judgment of another? Okay, and the judge covered the English language. Is there anything I didn't ask y'all that I should have? Is anybody, I wouldn't want me on the jury for whatever reason. Anybody? This is the last opportunity I get to speak to y'all. From now on, it's just more of a one-way street here. There we go, number 2.
I'm a federal probation officer. I've been in law enforcement for the better part of the last 10 years. I've worked with offenders specifically in this situation. I also have taught criminal justice classes at the collegiate level for the last 7.
Okay, and do you think that you could be fair and unbiased as a juror in this case based on that background?
To a point.
Okay, can you expand on that a little bit?
My inherent responsibilities as a person, as well as the years and experience out in law enforcement, are to protect the community.
Okay, so are you going to hold this to our burden? You're not going to hold so you'd be biased towards the state?
Yes.
Okay, all right. Anybody else have anything like that they want to let me know about? All right. Thanks for y'all's time.
All right. Does anyone need a break? All right. All right, I heard rumblings. Is that a yes or no?
Oh, man.
All right. All right, defense, are you ready to proceed?
Yes, ma'am. May it please the court, counsel. Good afternoon, everybody. I want to start off by talking about what is it we're trying to do in this space of the trial that's called voir dire. I think you kind of got a sense of it from the judge's presentation as well as the state's. I want to make sure that we cover it one more time. Not very long. As you can see, our presentations are fairly short. So this part of the jury is called voir dire. What does that mean? We want you to be truthful. When we ask you questions, tell us the truth so that we can make intelligent decisions about whether we think you're an appropriate person for this trial. As you can see, we have a lot more people than we actually need. We only need 12 right here. And we have like 4 or 5 times that many. Why is that? As juror number 2 very clearly demonstrated, there are some people that may not be appropriate to sit in this kind of a trial. Maybe you're better suited for a civil case or an injury case, right? And that's why I want you to tell us the truth. I can't be fair because, and you fill in the blank. Now, everybody comes to jury service thinking they would probably be a good juror, and you don't really realize that maybe you're not fair until we start asking you specific questions, and you see what kind of case you're going to hear, and then you start realizing, well, I do have an opinion about this, and I have a very strong opinion about that. And so we try to jog those or ask you to reflect on those issues. And then just tell us, I can't be fair, or yes, I can. If you're not sure, think about it, because we're going to come back to you and ask you for a commitment. Because you can see how if you were in trial and or Mr. Lozano was sitting here today, you wouldn't want 12 people sitting in the box that say, I'll do my best. I'll try to be fair. I'll try to follow the rules. That's not very reassuring. We really need people to make commitments. I'll follow the rules as given to me by the court. I will not consider any evidence that's not presented in the courtroom. I will not let my personal biases, opinions, or experiences influence my decision. I'll base my decision solely on the evidence presented to the court. Now, going back to counsel's suggestion, obviously you can use your common sense, things that you've learned in your lifetime to help you make decisions, but you have to base your decision on what the evidence is presented. So how do we demonstrate a biased person from an unbiased? I thought about the idea that today's election day, some of you may not know that, but I'm sure some of you saw people downstairs, they were voting. So when a person goes to vote, does that person go with an open mind and they're gonna look at the ballot, and they're gonna think everything through, and then they're gonna make a decision. Probably not. Most people that make the effort to vote is because they're in favor of a certain cause, a certain candidate, a certain referendum or amendment on the ballot, that they personally want to make sure they side with that person or that idea, right? So it's the exact opposite of what we're asking for you to do in jury service. We're asking you to come here and not have any preconceived notions about what your vote is going to be, right? Because if you have that, then you're not really giving the defendant a fair trial. And it's doing a disservice to everybody. Imagine the scenario when you're back there deliberating, and somebody says something along the lines of, I knew I was gonna vote this way because when I heard it was a theft, I mean, I just hate that. Everybody else should look at that person and go like, were you listening to anything that happened in this trial? That is really a very unfair situation, and you should have said that when the lawyers give you a chance. So right now is the time to give you that chance. So the second thing that might disqualify you from jury service is if you can't follow the rules as the judge gives them to you. You've heard mentioned, I think a couple of times, about the defendant's right to remain silent. Some people, if they're honest, will tell you, I have a problem if somebody doesn't explain themselves. Because if I was accused of something, I'll be the first to explain why they were wrong, why I should not be excused, etc. And if anybody is in that situation before a jury, before a court, and they refuse to testify, I'm going to hold that against them, right? That's kind of, it's not going to make or break the whole case, but if I'm kind of teetering which way I'm going to fall, that might push me over, right? It's perfectly fine to feel that way. That opinion is understandable that people would have that, but you can't have it if you're going to sit on the jury because the judge tells you you can't, right? So if you can't follow that rule, this is the time to tell us. I think I'm a fair person, but I've got a problem with the right to remain silent. I want to move on to the next subject that I want to cover, but let me start with anybody here feel like they have their mind made up just with a little bit that you've heard up until now, type of charge that it is, and what we're going to be doing. Anybody? Okay. Anybody here feel like they cannot follow the rules, whether it's not holding it against the defendant, his right to remain silent, or you don't like the standard proof? In other words, you don't think it should be as high as beyond a reasonable doubt. You think it should be lower because it's a theft case. And we should protect people's property. Anybody want to jump in on any one of those topics? Okay. I want to talk about the burden of proof. Burden of proof means who has to bring evidence before the jury in the trial. Anybody want to jump in on that other than the lawyers that are in there? Who has to bring the evidence forward? Anybody? Number 57?
It has to be the prosecutors,
Okay. And do you know why that is?
because it is the state that is bringing charges towards an individual who is presumed legally innocent.
Perfect. Exactly right. So let's say, for example, in trying to meet their burden of proof, the state brings forth evidence that the value of the item stolen was $295,000, not over $300,000. What, anybody want to venture an opinion about what the juror does in that situation? Well,
Maybe ask a question, if the charges were brought based on the 300,000 or the dollar amount, then if it's under, then didn't prove their. I don't know.
you just answered the question. Anybody else? What is she trying to say? Not guilty. Not guilty. Who said not guilty? Number 7. So the point is, they can bring you forth evidence, and they can bring 72 witnesses. But after all those witnesses, you didn't get everything that you needed to get beyond a reasonable doubt. Right? Let's say, for example, the jurors all go back there and say, we all agree, we're unanimous, it was 295,000, and the jury charge tells you he's charged with $300,000 or more. That tells you that's what has to be proved, right? What do you do if you're put in that dilemma? Well, you have a theft, but it's not what they're trying to come up with something more than what they've actually proven. I don't really like the idea that clearly some kind of theft went on, and $295,000 is a lot of money. What does a juror do in that scenario? Anybody? One?
Well, go back to the whole thing, space rights beyond what's out, but.
What I hear her saying is you follow the rules, right? They have not met their burden and proven what they've brought to you that they said they were going to prove. Whether you like it or don't like it, you have to say not guilty, right? I think everybody's following. So the follow-up question to that is, if you're put in a situation where you have to vote a verdict that you dislike, that you find distasteful, that you don't want to be in that situation because you're concerned that I'm not going to let somebody who stole $295,000 worth of stuff off because they didn't prove the 300, and then just disregard it and do what you want. Anybody think they would struggle or have difficulty or not want to be put in that position, and therefore couldn't be fair and impartial? Comments, questions? What I'm gonna do is I'm gonna call out your numbers and make sure that you want to keep them up. Keep it out for a second. If you think you cannot be fair and impartial because you're not gonna hold the state to their burden of proving exactly what they've charged in the indictment, because you might have this ethical dilemma, and you're not gonna follow the law, you're not gonna hold them to their burden. That's what you're telling me by raising your cards. So that still applies. Go ahead and put your card. 8, 6, 18, 21, 39, 52, and 69.
Before, I got a question before I raise
Go ahead.
mine. Where does the estimate come from of what was taken?
Well, as the judge said, we can't really get into the facts of the case. What I can tell you goes right back to what I just started with, which is burden of proof. State has to put on that evidence.
Yeah.
That little blurb they put on about what he was charged with, those are called elements of the offense, meaning all the different pieces of the puzzle that the state must bring proof of, right? If they never bring anybody in to testify as to value, let's assume nobody says anything about it. They just say it was a bike. Nobody ever says about the value. Well, they haven't proved the element of value. You go like, well, you might have stolen the bike, but they have to prove a certain value, and nobody testified to that. You're back to where I started, which is they didn't meet the burden, and you have to find them not guilty, despite the fact that you may think something you don't really like occurred. So the burden is always going to be theirs, right? The defense can put on evidence that tends to disprove an element, but your deliberation is not like, well, we believe the state more than the defense. No, we're still with the state's burden. The state still has to meet it beyond a reasonable doubt. If the defense witnesses help you, great. If they don't help you, great. If you disregard them altogether, the state still has the same burden beyond a reasonable doubt. Let's talk about one of the ways that we talk about burden of proof is to talk about presumption of innocence. So one of the ways I like to explain that to people, presumption of innocence is when you walk in the door and you see somebody sitting at the table with the lawyers, we kind of all figured out who the accuser is. And you have to presume he's not guilty, but you may start already kind of going down that path. Why? What do we know about people that are in court facing a trial on a criminal case? You know they got arrested, right? If it's a felony case and a serious case like this one is, we can assume maybe somebody in the police department investigated this, a detective investigated. Might have gathered witness statements, look for crime scene video, look for witnesses, that sort of thing. And then that person takes his report and he forwards it to the district attorney's office. We can assume, common sense is that somebody in their office is going to look it over. Does it meet the elements of a crime? What are we going to charge this person with? They make sure everything's in order, and then they go to the next step. If it's a felony, they take it to the grand jury. Say, grand jury, here's the evidence we have, and we indict this person. And as you know from sitting here today, he's been indicted for the offense the state has laid out for you. So some people, call me cynical, but some people might think got all these steps that have kind of all gone in a row that have gotten us here today to this man standing trial. Kind of starting to lean in that direction already, right? Even though you haven't heard one word of testimony. You haven't heard from a single witness. You have no idea what the facts of the case are. So the question is, does anybody here have a problem saying honestly that I'm presuming Mr. Lozano innocent at this point? Or are you starting to lean and are you concerned that maybe you're not? 52. Okay. I want to talk about this idea that I like the stolen bike thing because unfortunately I've had a couple of bikes stolen. If you have your bike stolen, right, and you're just going about your business on HEB or doing something, and you see a bike that looks like yours, and you start following that person riding that bike, you go like, that is definitely my bike. What goes through your mind in terms of what you should do in that situation, or what you think about that person? Anybody? And we assume that that person who's riding it stole it? Could that person have come into possession of it with no knowledge whatsoever that it was stolen? Are there places where you can buy things all over the place, the origins of which God only knows? So if you're brought into court and you're charged with theft, and you said, I didn't intend to drive anybody of anything, doesn't the state have to prove that part as well? Anybody here ever go to the bank and have money kept because the teller said, that's teller? Who has that happened to? Anybody? Number 13, did you get arrested?
No.
Why not?
Because they didn't know how I got in possession.
Exactly. Number 6?
I've gotten counterfeit money from the bank.
So,
I was just asked where I got that $100 bill or the money that I had.
but isn't it fair to say that number 13 didn't get arrested and the police didn't get called? His common sense would suggest the scenario that there's no way to know. There's no basis to believe that he actually did anything wrong, right? I want to ask one of the questions that's on your cards, prior jury service. Who's been on prior jury service? As I call your number, can you tell me if it was a criminal case or civil? What the verdict was and what kind of case it was? 23? Civil, okay. I'm gonna skip over it because it's not criminal. 22?
I've served on 2 juries, 12 person, 6 person. One was criminal, one was civil.
Okay, on the criminal case, what kind of charge?
It was a statutory rape case,
What was the verdict?
not guilty.
Were you the foreman?
No, I was not.
Okay, thank you, sir. Number 27?
Several years ago, I don't remember, it was in Chicago.
Okay, so nothing about that experience that would cause you to believe you couldn't be fair in this case.
Correct.
You weren't the foreman in that case?
I'm sorry,
Were you the foreman in the case?
was there what?
The foreman, the poor person, the person who's in charge of the jury.
Oh, no,
Okay. 35?
it was a civil case back in Ohio.
Okay, thank you, sir. 38?
It was a homicide criminal case here in San Antonio.
And the verdict?
Guilty.
And were you the foreman?
No.
Thank you, ma'am. Number 40?
It was a criminal case,
What was the charge, you remember?
kidnapping.
Okay, and what was the verdict to the jury?
It was a split verdict.
There was actually no decision.
Yeah.
Okay, thank you, sir.
3
41?
minutes. 3 minutes.
So civil case.
Okay, thank you, ma'am. 48? 48?
I was on 2 civil cases. One was guilty verdict against the extra company. And the other one was traffic infractions, of which we said some of it was guilty, some of it was not guilty.
Okay, thank you, sir. 56?
It was unlawful termination,
Okay, so, civil case.
civil case.
Sorry, guys, I'm gonna skip over y'all only because you haven't figured out your likelihood of getting on the jury when you're this far down the road is not as high as these folks. I'm kind of running out of time. So the last question I want to cover is, juror number 2 gave us a perfect example of somebody who has real life experience that kind of really overlays a lot of what we're doing here in this trial. So what I want to ask is people that are either in the law enforcement field, legal field, whether you're attorneys, investigators, paralegals, anything that's related in any form or fashion to a court process involving a criminal case. Do you think you can be fair and impartial, or do you have concerns about that? That apply to you. 52? What do you want to tell me about that?
I'm not currently a paralegal. I was for 10 years.
I'm sorry, the court reporter is having a hard time hearing.
As a paralegal for 10 years, I'm not currently a stay-at-home mom, and I'm related to 3 retired police officers, my father, my brother, my sister. And I tend to believe that if an investigation was done, they've done it correctly, especially if my sister being.
Okay, thank you, ma'am. Last question. Does anybody here on this, in this group feel like they could not be fair and impartial or would not be appropriate for this trial for any reason, whether it's something we asked or just something that you know about your personal experience and your personal feelings that you need to share with us? Anybody?
Struggle with that ethical element of it, and I understand that there's so much like judgment and this is like a concept very grand, and I don't know, I just feel like if we have an ethical dilemma, I'm not sure like how are we do it, or yes.
All right, your time has expired. All right, ladies and gentlemen, I'm going to have you all leave your numbers behind. Take your personal items with you, and we're going to have you line up outside, and then the deputies will bring you in to let you know which persons will be on the jury. If someone needs to use the restroom, find a stairwell. Wherever the stairwell is, a restroom is on either side of that stairwell.